Bail application.
Charging has already been filed.
Bail application
Under the hearing.
under the heading on Tuesday.
Okay, sir. I don't want.
Yes.
Yeah, especially direction analysis of the class work. But here whether the private restaurant is not the stuff. The track report has 5 alert. It is yesterday, last is with the event item. So, but the order, it is stated on third, the matter to be scheduled. That's why
So notice not served.
so it is, notice have already, as per the direction on 27th, by speed post have,
What is the track report says?
so that 5 in the, it's the page, last page number. It's, yesterday it is mentioned, item bank.
Okay, Nani, I'll leave. You are having the copy?
Correct.
Bagged, not received.
From 27th it is.
27 you sent.
26.
Dispatch, time bank, 3rd July. Yes. What you are prayed for?
Private respondent, she entered into the grant has, as per the regulation 161, or made a complaint for the September. Now the September, she has found the order on 22nd of May 2025. Can we look at page 70?
Yes.
It's mentioned here,
Until demarcation.
demarcation.
Correct.
Can we vacation order? 1.8, without intimating, without demarcation, without hearing me, this order has been passed.
So after 22nd May 2025 till 12th of June, what has happened? You are appearing?
So there is this factor, Menard has, if you remember, Menard was the factor. Based on Menard's case in report, the degree has been.
In this matter? Release.
Is already pending.
Release.
But between that was there and this is there.
Is this granted? By?
On 26, last order.
By this court?
Last, on 26. There's the order.
Due to personal reason, the matter is released from the list of this court with the liberty to mention, with the liberty to the petitioner mentioned before the Honorable Court number 1.
Right.
We are the वापस दे दें.
Not instructed strictly not to appear in this matter, but since Bobo was not to, I'm other office.
I am
Yes.
appearing for the respondent, Lordship.
Yes, Mr. Mishra. What is your instruction?
Lordship, his application is pending, Lordship. In accordance with law, we will consider it.
Whether name of the Japal is to be recorded or not?
As your Lordship is. His junior's name may be recorded, Lordship.
Yes, Mr. The petitioner has filed the present application, praying for a direction upon the respondent authorities for providing electric connection in the residential house of the petitioner standing on survey number 345 by 2, measuring an area of 400 square meter, situated at Ravindranagar village, Hadwe, Handal Literaman Tehsil, Southern Amman district. Police. For the petition submitted, the petitioner has applied for grant of electric connection by an online application number 29542 dated 28th of April 2025 by disclosing all the required document along with the affidavit and undertaking, but in spite of receipt of the said application and the document from authorities have not provided the electricity connection. Counsel for the petitioner further submit that the petitioner has occupied the said land and constructed the house and is in settled possession of the said landed property and prays for grant of electric. Then Mr. Leonard Advocate Satish Mr. Leonard Advocate appearing for the authorities submit that the application filed by the petitioner is under consideration. In view of the above, this court find that no purpose should be served by keeping the present application pending. Accordingly, WPA 292 of 2025 is disposed of by directing the
Respondent number 1, Lordship.
respondent authority, particularly respondent number 1, to consider the application filed by the petitioner for grant of electric connection and to provide electric connection to the petitioner within a period of 4 weeks from the date of compliance of all formalities.
Obliged, Lordship.
UPS sensor disposed of. Next. Yes.
Lordship, item number 3, Lordship, I required time till Monday, Lordship. I could not able to get the instruction from, it is from
Yeah.
Dignity, Lordship.
Monday. As per prayer made by the counsel for the respondent, the case is adjourned. Let the matter appear on 7th July.
Obliged, Lordship.
Next.
Run for the appellant.
Yes.
Partition was filed. Share has been claimed. Interim order was not granted, which traveled up to here, might not have an occasion to pass certain protection. Interim protection. Then the district judge refused to pass the interim order. Again, that was challenged here for the second time. Upon 2 costs taken on trial. The defendant admits my share in the written statement. Defendant's cross-examination admitted that I want to give the share. Despite that, the civil judge senior division court not kindly see. The reason behind is since I have attended a Bhumi Puja, that is the sole reason why my suit was partition was dismissed. But this appeal can be taken up to action.
And you have applied for the mutation in the name of your mother.
Applied not judgment, not title is not created, not most law.
Correct.
Title and there's no relinquishment deed, nothing is there, no.
So appeal is to be heard.
No, it's not necessarily one thing. No, we still have 8 days in our hand. It's an appeal of 3 witnesses from my side, admission by the defendant, admission in the allows the entire application.
I have no problem if the other party comes and he.
I'll give you notice. Lordship, on I'm praying for some interim protection because by virtue of the interim protection so granted the disposal has now been vacated by the interim judgment. I have filed an application for stay.
So notice.
No, I will come. So order 41 rule 11 Lordship, some protection needs to be given. Lord. Otherwise, Lordship, what would happen by the interim judgment? The interim order is vacated. The transaction will again start. Not kindly see the interim judgment once. And I'll show the order of these courts passed twice. The interim judgment not to see last but 1 page of this stay application has been vacated. But had it been a complicated civil suit, even I could understand. The partition suit defendant admits my share. The civil judge.
Where is the plaint?
I'll show you. Not kindly take up my stay application. The plaint would start at page 11. Page 11.
Preliminary decree shares partition suit.
Yes. Admission I'll show us. In the written statement in the defendant admitted in clause. I'll show the written statement admission. Not kindly turns to the written statement. 34, page 34. It's part of the written statement. Turning page 34, internal page 4. Paragraph 7, third line. it would be germane to mention here that defendant number 1 as on date is ready to give the share to the plaintiff in the suit land. Property has agreed only between plaintiff and defendants prior to taking up the construction on flat so and so. Moreover, the plaintiff has agreed to for such settlement and thereafter the plaintiff never made. Paragraph 8, third line. The defendant number 1 at no point of refused to give share to the plaintiff in this property. I'll show the cross-examination of defendant. I'll just show first one line, not kindly turns to page 142.
So why you not filed order 12 rule 6?
No, admission because in the written statement they have prayed for dismissal also. That's the whole reason. In the body they have admitted it, but in the prayer portion.
Any part thereof.
Absolutely,
Any part thereof.
Absolutely. So can you see page 142? The cross-examination of defendant herself. 142, 143. I'll just place 3 paragraphs, 4 paragraphs from the top. It is fifth paragraph. It is fact that Vijay Lakshmi has a share of this property. Next, Vijay Lakshmi has not executed any documents languishing her share. Now, can you turn to page 143, last but one paragraph.
Who is the defendant?
Yes, defendant number 1. 143 last but it is a fact that I want to give equal share. What else is required, Lord? The trial court simplicity order based on this admission could have decreed. But dismissal, no reason, no guidance in the reasoning.
So what stay you not required?
Lord, what has happened? Stay has been granted till disposal of this. No consider. I'll show that.
Where is that order?
I'll show that. Stay needs to maintain, not I'll show that. Now, can you see page 2 to 4? This court had occasion to deal with this matter when the appeal was pending. Some protection was granted at page 2 to 4. 2 to 4.
My order.
My lord. Then, my lord, the matter was taken up by the district judge. District judge granted stay. District judge granted stay, which was challenged again before this court. The district judge order is at page 235. After this order was passed at page 2 to 4, the district judge takes up the appeal, order 43 appeal. Page 235, we can be seen, note. Page 235. Both the parties are directed to maintain status quo as to the nature, character, or position to as on till disposal of the suit. This order was again challenged before this court, which is at page 239. Rejection. 239. The division appeal was dismissed by maintaining the order of the district judge. Now, since the suit has been dismissed, the civil division has vacated the stay. They would merely continue with the construction lawsuit. The nature and character would be changed.
The appellant has preferred the present appeal against the judgment. Where is the decree? You are not appealing decree.
He has not been wrong.
Have you taken leave?
Under order 43 rule, there is
Correct, but leave.
It has to be obtained lordship.
There is no prayer. You have not made a prayer in the.
Because order 40 is one.
Correct. But the leave is to be at the time of hearing. You have to file the certified.
Make an application. Because there was an urgency to have to court this appeal, not the very urgent. It will be drawn not within the statutory period as provided in the single motion order. Judgment is at page 1C.
क्या बोला? Present appeal against the judgment filed by the learned civil judge, Senior Division, Southern District, Port Blair, dated 2nd July 2025, entitled suit number 35 of 2023, within bracket Srimati R. Vijaya Lakshmi versus R. Satyanarayana Amma, Srimati R. Satyanarayana Amma, and others. Full stop. The plaintiff had filed the suit for partition of the suit property. Full stop. Partition of the suit property. The defendants, in their written statement as well as in their deposition before the trial court, have admitted that plaintiff, being one of the legal heir of the deceased Dhanraj,
Yes.
the deceased Dhanraj is entitled to get her share over the said property. Counsel for the appellant. The appellant has also filed an application. The Leonard Civil Judge, Senior Division, has dismissed the appeal and dismissed the suit only on the ground that the plaintiff was well aware of the fact that the construction of the building of the suit property, and she was also aware that suit property was mutated solely in the name of the mother, and the plaintiff has participated in the Bhumi Pujan of the suit property, and the plaintiff has made an admission during the cross-examination. Where is caveat? No report? No report? Report नहीं देते? Call the OS who is affirming this. Call. रिपोर्ट नहीं आता कैबिनेट का? कहाँ है? कहाँ है? कैबिनेट एप्लीकेशन है. Where is the report? Where is the report? Report has to be here. Call the office. Then serve the notice, Mr. Jafar.
So may I say one thing? But there is an admission I just drawn. But this very appeal can be taken. I'm trying.
It is up to you, but both the parties agree. I have no problem. This court is no problem. I will take the appeal in the both the parties.
It's not taken up,
But with regard to the CAN application, when the caveat is there, then serve the copy.
Here and now. I've not received a notice of failure information other than I could have given. It was sent to post.
Not received. You have not received the caveat.
No.
Only receipt is there. Okay, come on Monday. You will not be available. Tuesday. Come on Tuesday. Come on Tuesday. Record an order. Okay, also can't go. Mr. Rakesh Pal Govind, non-advocate, appeared on behalf of the opposite party and submit that he has filed the caveat. This court find that caveat is on record. The plaintiff has served the copy of the CAN application along the copy of the appeal and to the land council for the opposite parties. Let the matter appear on 8th of July.
Agreed.
Just a minute. You are not noting the caveat which it is filed in either in the appeal or in the CAN application? कहाँ देखो?
Yeah, appearing for response. His minutes are appearing for the petitioner. Wait for a short pause over.
Who?
Gopal music.
Pass over. Pass over. Next. You are not appearing. You are appearing.
This morning only he has written the file, sir. Petition matter, where issue related is regarding the discretion of the director of shipping service to declare the union as majority union.
Okay.
It is relating to in this island, that is the postal sector and the maintenance sector and the contractual employees. What had happened, my lord? There are four unions in this island. One is MUTI, then Sailors Union of India, one is FPP, and then NSU. One of the union, that is mostly filed a writ petition before the learned single bench of this honorable court. The judgment appears in the affidavit in opposition, my lord. May I just request my lord to kindly take the opposition of the added.
What is the prayer in the writ petition?
I filed a writ petition 70 times, my lord, because they have not taken into consideration while passing the minutes of the meeting. Because
Already held.
as per the single bench, they have called for a meeting. May I just receive to kindly answer our of the in 14 of the 11th single bench.
Opposition.
Yes, my lord. Of the added Mr. Minu Kumar on their behalf.
Who has affirmed?
It is the union, my lord. It is the union.
What is the name of the person who has affirmed the affidavit?
Dharminder Ram.
Yes.
My lord, connection. R. This is the ordinary single bench dated 8th December 2021. The operating portion, my lord, if I take my lord, it is page number 16. Last but second para, there is December 2020, claiming that he did not have the jurisdiction to decide such an issue. The writ petition is confined to a sector of the industry and not represent the shipping industry in its entirety. That is the shipping service. Decide the issue of majority union as claimed by the writ petitioner. The writ petitioner union filed a writ petition for the alert single bench to declare them as a majority union. Opportunity of hearing to the petitioner before taking such decision. This man finds that liberty to use such other parties and on this matter, other parties and consult such documents that it deems necessary as a reason. Was taken last part of the order in that he will pass a reason order within night. Why I say this? He come to my petition. At
Stop. This is the order of 2021.
my lord,
2021 now written order was passed. No,
the order was passed.
where it is.
It is at page number 3 of my petition, my lord. Kindly, my lord, kindly come to the petition. Contents of this, I am reading the notice. It's conveyed under the chairmanship of the Director of Shipping Service in the conference hall of the Director of Shipping Service at 11 a.m. to discuss the shore sector and the island sector. Record committee
Yeah.
I will see the last portion of the page number 21.
You you're representing NSC, ANSU,
SUI, Selection of India.
SUI.
Yes, Sanjay Kumar.
Yes, he was present there.
Yes. My lord, the kindly take the last. My lord.
Yes.
Later, the director was heard and the grievance submission by the General Secretary representative on behalf of the petitions, wherein namely Sri R. Sanjay Kumar, who is the R. Sanjay Kumar, General Secretary, SUI, Vinesh Ram, General Secretary, SUI, Vidhi Prakash Krishna, General Secretary, ONSU, requested the chair that the majority decided by involving seafarers to secret ballot.
Correct.
This is checking method. This checking method is my lord. What the so sector. On 70 charter. So secret labor commissioner for declaration of majority union the roster through. So participate decision. I will follow this.
He's a merchant shipping. Merchant Shipping Act.
Section 97 capital A, my lord.
Yes.
Prohibition against discrimination. There shall be no discrimination between seamen on the ground of the ownership or lack of ownership in any particular union. Interest of seamen and membership in such union shall not be put conditions. Parties. I am also a contractual sector. So they can discriminate that I am not a permanent crew. So I am not entitled to fundamental rights, which is the constitution. Now thereafter, my lord, with the permission again, I am listening to last para, my lord. This is very important. And the should should consider should should contents. So should So my consider these also. Kindly come. Page number R. It is letter to some. You can see contains my word. As per the several conditions option government service act 1958 and the dispute act and does shield. See powers of internet, chief subscription seafarers concerned. You can calculate the strength of seafarers. State and poverty education. Side standing despite the since some charter of kindly come to action. This meeting is held on 18th on 7th.
Yes.
There and the school started
Yeah.
thereafter there sectors.
Yeah.
Uh, that-
Yeah.
Again, that dated 2000. So my humble submission and prayer in the reason is my Lord to keep hearing 17/10/2000.
What is the stage? What the authorities are
They
saying?
have given
Already given?
given.
Hmm.
They have given since they go to that association.
Yes, Mr. Payne.
The court has passed an order,
Yes.
and under the hint of the order of the court,
Hmm.
the proceeding was initiated.
Correct.
all along they participated in the proceeding. My lord, can you see page 41?
Yes, they appeared, no
They
problem.
appear.
Yes.
Now they appear, and if my lord come to last paragraph of page 21.
Hmm.
Later, the director has heard in length the
Hmm.
demand grievances submission made by the general secretary representative on behalf of the respective unions, wherein namely so and so, his name is there,
Correct.
so and so, so and so. Requested the chair that the majority may be declared deciding by informing all seafarers to the secret ballot system to get the commissioner for declaration of majority in the
Hmm.
among the roster crew and contract crew members. Whereas the director has cleared that only roster crew members shall participate with the written consent for declaration of majority,
Hmm.
being permanent crew member of the director. Now, my lord, we find that roster crew members are those members who are working in the vessel and who are there in the roster. So far as majority agreement, when a union is declared as majority union, that is binding upon the
Admission.
the administration in respect of the roster crew,
Correct.
not in respect of the contract crew. So, my lord, therefore, this is what the finding of the authority saying that it will be only through roster crews.
Hmm.
Thereafter, it says, the director on chair inform all the other people that the director has received a letter from the labor commissioner that the labor commissioner is not the authority to decide the issue of recognition of union in respect of
Shipping certificate.
now, my lord, me, the document, my learned friend referred, which I cite, thereby the labor commissioner in clear terms says that authority. And if my lord sees page 21, last paragraph, wherein the secret ballot and all that was by the labor commissioner initially. So labor commissioner did not have any authority on that. And therefore, my lord, the director is the competent authority to decide. After that, after a long discussion, the chair has asked the general secretary representative requested to submit the written consent from the crew members by the respective union for declaration of majority union, and they were given sufficient time to decide majority union for negotiation of wage agreement on their mutual consent. Understanding, in spite of that, they were not arrived to any conclusion.
Correct.
Now, no general secretary even submitted charter of part. The detail,
But this, no general secretary represent chartered, but their chartered demand is on record.
that is permanent, they are contract.
Who?
This petition is for contract. Permanent cards.
We have contract and by contract as well.
No, but the director could have been listed and the representation which has been received, that is not a permanent roster, that is the where he has decided that.
No, can you see? Further, it is said meeting to be called for negotiation. Now, madam, can you see the next document number?
Hmm.
Madam, can you see page 43?
Correct.
A meeting of declaration of majority of international of so and so in the conference order of so and so is desired. Here also here appeared.
Hmm.
The director of sitting on chair has informed all concerned general that the majority union was declared to for both Foresaw and now the meeting has been called for the purpose of deciding the issue of authority for the result and announcements of the crew which is since so and so. And the director requested all the representatives to submit the list of crew so and so which are majority wherein the claim of 45 crew members, the representative meeting stated that there must some dual members that they so and so, so and so. Earlier by the director so and so. My lord, we can see thereafter. Next paragraph, the written consent of crew members submitted by ANSU and has been verified and found that there are 9 crew whom both ANSU and UC were claiming to be members. The membership of this group thereafter verified by Kutal based on the personal consent and found to be member of the ANSU. After scrutiny of the document, the director statement is all a majority of member in interallied sector, therefore, duty representative withdrawn his claim. The director thereafter requested all the incorporate so and so. So, my lord, entire exercise was adopted. Here also the copy was applied to it. Now, my lord, may kindly see the order which was passed, my lord, on the basis of the order passed by this court, page 25.
Yes.
It says that whereas National Seafarer Union filed the writ petition.
Page 25 of the writ petition. Page 25 of my writ petition, my lord.
Yes.
It says whereas National Union so and so filed a writ petition and High Court has directed to decide an opportunity, the respondent has liberty to hear. Now, my lord, can you see the next paragraph? Whereas the process adopted in past for deciding the majority status of trade union, the membership strength of permanent roster, my lord, can you have a note of this, my lord? Crew with their respective trade union were taken into consideration and calculation, my lord.
Yes.
Based on such calculation, the majority was required. My lord, kindly consider this, my lord, wherein it was categorically stated. This process was adopted in part for deciding the majority status of trade union. The members of permanent roster crew with their respective trade union was taken into consideration and calculation. Based on such calculation, the majority was arrived. So, my lord, the order of this court and the proceeding which was initiated was to consider the majority union on the basis of the permanent roster rules. And that exercise was undertaken, and on the basis of such exercise, the decision has been arrived at.
Correct.
Where is the recommendation of the labor commissioner to calculate so and so.
So this is a 2022.
2022, after the order of the court.
Correct.
After the order.
And when you file the writ
So
application?
the writ was filed in the year 2023. No increase order was praying for, and my lord may see.
What is the tenure of the?
What is that? What is the 2023?
2.5 years is over.
My lord, can you see at this juncture, if my lord interfere with it, my lord, then it will be already a union has been on the basis of.
My lord, my concern is that, my lord, I don't want that there should be for the union only. But at least kindly see the order, which is was taking some other process to just identify the majority. But the order says, and whereas the deciding the majority status of trade union, the membership strength of respective trade union stated into consideration calculation. So the process is simply my brother
Now what you want at present?
kindly come. My lord. My lord, Lucy has been very.
Now it's correct. I appreciate. Now the majority has been correct. Whatever the consent from the permanent crew or whatever it may. Now 2.5 years is over. Correct. Now if at present, if any order is passed with regard to the representation, the director will into an order already the majority has been declared at present. So it would be better, subject to correction. Whenever the occasion arise, you take the appropriate application. It has been happened on the last occasion, so it has to be a secret ballot. That can be done. That be better.
Well,
Because at present, what
even to just see that the union is defunct and then new process is taken up because contract crews are also onboarding the ship. So we don't want ultimately to see what is the process and how it is to be adopted. Because as per the Merchant Shipping Act, as 97A says, there should not be any discrimination. It is not settled.
before election, before this decision, you take appropriate steps, writing to the authority.
They don't ask submission. The Merchant Shipping Act says that they should not discriminate. That means that a contractual crew, CTC holders, you should not be paid different wage. That has.
That's all.
It's not possible for this court to decide that. That already you have taken the decision.
What I'm submitting is, that doesn't mean that they have a right to be, non-permanent crew members have a right to be included, my lord, in this process.
Then we have to amend the constitution altogether.
Because, my lord, they are free to work here. The issue is roster crew. They are not permanent roster crew. They have no.
I don't think is not pertaining to the roster crew members.
Then you take a decision on the next, whatever it may be.
But this application is not maintained. At this juncture, it cannot be.
But you will continue with this writ application or you want?
Let me dispose of asking an appropriate order.
Let me kindly have a note of page 23, my lord.
That's
Yes.
I can just. And petitioner has filed the present application. Praying for a direction upon the respondent authorities for consideration of the representation Where is your representation, Mr. Rakesh?
My lord, I'm to it, my lord.
27.
I'm to 27, my lord.
Representation dated
17/10/2022.
October 2022, submitted before the Director of Shipping Services, raising raise certain points for discussion in the meeting to be held on 18th October 2022. Counsel for the petitioner has brought the attention of this court to the or asked by this court on the earlier occasion in WP number 1 WPA 180 of 2021. Dated 8/2020, wherein this court has passed the following. Page 16 and 7. In compliance of this order dated 8 December 2021, the officer in charge of the Directorate of Shipping Services has issued a notice on 7th October 2022 informing that 18th of October 2022 a meeting will be held for declaration of majority union for wage agreement pending for foreshore sector and mainland sector. Accordingly, on 18th of October 2022, a meeting was held wherein all unions, representative of all unions, as well as the officers of the administration have participated in the same. In this meeting, the petitioner union, your union or personal
Union, my lord.
petitioner
Teachers Union of India.
petitioner union has raised an objection that the majority may be declared/decide by involving all seafarers through a secret ballot system through Labour Commissioner for declaration of majority union amongst the roster group and contact group members. But the Director of Shipping Services has made it clear that only roster crew members shall participate with consent for declaration of majority being permanent crew members of the Directorate of Shipping Services from Andaman and Nicobar Administration Board. The Mr. Rakesh Palgovi has drawn the attention of this court to the minutes of the meeting 18th October 2022. Wherein it is recorded that no general secretary representatives have submitted chartered of demand and details of records of membership of permanent roster crew of foreshore and mainland sector except NUSI for majority is two sectors. Mr. Rakesh Palgovi draw the attention of this court to the communication dated 17th October 2022, wherein the petitioner and union submitted their points before the Director of Shipping Services, but the same was not taken into consideration in the minutes of the meeting dated 18th October 2022. Counsel for the Mr. Rakesh Palgovi submit that as the representation and the points raised by the petitioner union is still pending and has not been decided, lest such direction may be issued upon the authority to dispose of the said points raised by the petitioner. But contra Lana advocate Mr. Gopala Kumar Lana advocate of added respondent draw the attention of this court to the order number 3520 dated 28
October 2022.
October 2022, issued by the Director of Shipping Services, wherein the National Union of Seafarers of India is recognized as majority union for such purposes for a period of the tenure of 5 years, provided it is not found responsible for breach of the code during this period. Referring the said order, Leonard, Mr. G. Gopala Binu Kumar submits that the authorities have already decided the majority union, and thus nothing remains in the present writ application. Mr. Satabdu Chakravarti, London senior advocate appearing for the administration, submits that section 97 of the section 97 capital A of the Merchant Shipping Act 1958 is regarding the discrimination of the pay, salary, and wages of the crew roster of the crew members of the roster crews. It is not mentioned that the crews who are not the permanent in whose name has not been rostered in as a permanent crew shall be taken as to be considered taken to be consideration as member of the crew as the crew member, permanent crew member, and to allow to decide the majority union. Heard the Leonard Council for the respective parties. Mr. Chakravarti further submit that the administration has already decided the majority union by an order dated 28th of October 2025, and as such no order 2022, and as such no order was in the present date. Heard the Leonard Council for the respective parties for the materials on report. It is found that in compliance of the order passed by this court on the earlier occasion, the notice was issued for holding the meeting, and meeting was held on 18th October 2020. In the meeting, all the representative, all the unions, as well as the officers of the concerned officers of the Director of Shipping Services were also present. In the said meeting, the petitioners union has raised an objection with regard to holding the election with a secret ballot, but that was turned down by the Director of Shipping Services.
I beg pardon, my lord, we object for checking method. We object for checking method, rather we recommended for secret ballot.
Correct, cleared from roster. And subsequently, the Director of Shipping Services held that the National Union Seafarers Union is recognized as majority union. Now only the contention of the petitioner before this court that the petitioner has raised several issues before the Director of Shipping Services by a representation dated 17th October 2022, which has not been considered. Considering the above, this court find that no purpose should in this court find that the Director of Shipping Services already decided the issue by holding that the NUSI is the recognized majority union for the purpose of deciding the wage agreement and other purpose for a period of 5 years, and as such it is not proper for this court to disturb the decision taken by the authority. But this court cannot avoid that the representation filed by the petition is still pending before the authority. Accordingly, the Director of Shipping Services, who is the respondent number 3, my lord. Director of Shipping Services, that is the respondent number 3, is directed to dispose of the representation filed by the petitioner dated October 2022 within a period of 4 weeks from the date of the communication of the order, and by passing a reason speaking order, and to communicate the same to the petitioner within a week thereafter. WPA number so disposed. Next.
My lord has appeared, my lord.
Which one?
Item 7.
Parvez Zamal, release.
No, Sagar Engineering.
Sagar Engineering. Release.
In an earlier round.
It is better to inform because it is very impossible for me to. Correct. Yes, next.
Number 254 have been floor. That's saying for pass or release my for seniors.
Who is your senior? Japal, pass over. Next. Japal, all are Japal. Ah. Whether he will come or not. When? After then what the court will do?
But I have a password matter. my lord.
Which one?
I intend to argue.
Which one?
Item number 5.
Item number 10 and 11. Let it come, Mr. Japal come. Let Mr. Japal come. Yes, Mr. Binu, who is for the other side?
5. Satadru.
Then I had appeared in the matter, no?
No.
Why?
It was an electricity department, but my lord has not appeared.
Not appeared.
This matter was heard, but lastly they have taken time, earlier occasion. Have challenged the award passed by the labor court.
Where is the other side? He also left.
Satadru is here.
Yes, Mr. Chakraborty. Item number 5.
Order passed by labor court, my lord, actually, my lord, on a particular occasion, my lord, this matter had been argued. And at that time, my lord, upon the direction of the court, Mr. Kumar was directed to produce the bank statements. Now, he produced the bank statements in respect of some of them, or everyone. But 2 or 5 people are left.
Two people
Two
are.
people are left. So whether he may.
No, I am not, my lord. I will argue, my lord, because already everything is there. They are out of.
For why the bank? Whether it is the
Show
amount is-
bank statement to show that they were in service, that they were receiving.
My lord, they
payments.
worked for more than 10 years. What happened at the labor court by rejecting said that last 240 days whether they have worked or not.
That is the
For
test.
that, the court said you file a statement of bank statement so that it can be proved. So I have filed the bank statement whereby clearly prove that they have worked continuously. I have given more than 3 to 4 years bank statement before the court, which prove that they have.
But not in respect to all the.
Only, yes, I know, I have not filed in respect to, I can identify those 2 persons for whom I have not filed. I will.
So what is the regularization?
No, reinstatement.
Retrenchment.
Retrenchment.
On the what are the ground?
The ground is that they were replaced by another persons from APWD. Electricity, my lord was there when those system was introduced. Those excess labor from APWD were sent to electricity department. When they were sent to electricity department, these peoples were thrown out.
Mr. Chakraborty, whether this is of the draft of mine, I think so.
My lord.
Ah. Then.
Sorry, no, actually the brief is, I don't even have the brief.
Page 47.
If I had the brief, I would have informed my lord.
This is drafting. My lord has never appeared.
No,
Yes. No, my lord is, we don't know.
I had not appeared.
Yes, sir. Yes,
But-
yes, yes.
First have been my lord, because 2020.
No, yes, please.
No, this because this affidavit written statement was filed on 2020, December 2020. That's what I was there.
Fine, okay.
Release. That's why I think very difficult. Release.
Fine. Almost all matters my lord was doing in the island, not only High Court, District Court, everything. My lord. When we came here, we realized, we thought that there are so many matters in High Court, and the staff in the GP office said, then what are you saying? When my lord was there, the matters of all the District Court also my lord was. Imagining how, my lord.
When Mr. That before that, what is your name? Your colleague? Item number 8.
Kindly have a look through the Lord order dated 30th April 2025.
Who is for the other side?
Pavitra Madam. Yes.
What is your prayer?
Now, what had happened?
What is your prayer?
My prayer is, Lord, directing the respondents authority to take steps to allot the alternative land.
Alternative land.
My land, I've been given a license. My father was given a license. I'll show that. For page 32 is the license given to my deceased father, Noor Jamal.
Yes.
Possession was not delivered, Lord. Records are being maintained right from page 33. His death certificate, page 34, Lord. Revenues are paid, Lord. Then what happens, Lord?
Revenue paid.
Revenue paid, paid 2011,
Then he died on 2010.
10.
Then
Then, Lord, what has happened?
which area?
It's within Farganj,
Province Tehsil.
yes, Dhanikari.
Dhanikari. Yes.
But then what happens when the possession was not given to me at page 43, the Tahsildar Farganj proposed something. Lord, kindly see page 43. Then a report was called for from this court. I'll show this page 43. Non-compliance of solemn order dated 22/11/1991 in civil division, civil rule WP number 1991, inviting contempt proceeding of Honorable High Court. This has reference to the letter number so-and-so dated so-and-so received from Assistant Commissioner South Andaman, and another letter bearing number so-and-so dated so-and-so received from the readers to the Deputy Commissioner South on the matter of the petition filed by Mr. Sahida Begum, wife of late Noor Jamal, residents of Phoenix Bay, Port Blair, regarding non-compliance of order passed by the Honorable High Court on 22/11/1991 by the Tahsildar Farganj. The Tahsildar Farganj, by demarcation notice number so-and-so dated so-and-so, issued demarcation notice to the writ petition and other response for conducting demarcation over land bearing survey number 101/3, measuring area 2.02 hectares, situated at Dhanikari village, recorded in the name of writ petition. However, despite of issuing repeated demarcation notices, the aforesaid demarcation could not be carried out due to the non-physical position of land of recorded land. The said recorded land is in physical possession of Ayyappa Temple Committee, Foolmala Samadar and others, and Sri Joseph Ikka. The direction of the Honorable High Court was to be effected from 22/11/1991 within a period of 3 months. The direction of the Honorable High Court was to demarcate the land, and thereafter the writ petition was to fence demarcated area and accordingly fence the land. But till date, compliance of the Honorable High Court has not been carried out. The recorded tenant is paying land revenue upon the aforesaid land, and there is no arrears in record. The aforesaid land is in physical possession of other respondents. Hence, it may be suggested that an alternative site may be proposed to the recorded tenant in the light of a genuine case and to avoid contempt before the court of law. Then, my lord, reports were prepared. I approached this court on many occasions. Then, my lord, to see the order of this court, the authority passes certain orders at page 50.
Yes.
Page 50, by which my claim was rejected. Page 50 and 51, then 51, 52, 53. Then I approached this court at page 55. Page 55.
Yes.
And finally, this court, while setting aside those orders, to direct the Assistant Commissioner at page 59 to do certain act.
Assistant Commissioner demarcate the allotted land.
Yes.
Then
Yes.
the party so-and-so subordinate such exercise. Expect the entire exercise will be completed at least 3 days in advance. The authority also see that the action passes. Yes. Then,
my lord, a notice was issued at page 60 to my client. Thereafter, nothing was done. Then when I filed this writ application, this court passed an order on 2nd August 2024. Now, kindly have a look to that. 2nd August 2024 passed in the present writ petition. 2nd August 2024.
yes.
The assistant settlement officer is personally present today. A copy of the order dated 25th March 2024 was passed in WPA number 341 of 2013, which was subsequently confirmed in terms of the order dated 8 March 2020, is produced by Mr. Jaipal and Counsel for the Petition. In this order, the respondent number 3 therein was directed to propose an alternative site for the purpose of recording the name of the petitioner as tenant in respect to the same within a period of 2 months from the date of receipt of the said communication from SGO South Andaman, provided the petition is entitled such recording of allotment in accordance with law. There is office memo annexed to the writ petitioner, including the note dated 7 June 2012 made by Tahsildar Farganj, where providing with alternative was contemplated. There is another order dated 26/11/2014. It was stated that the proposal for a Alternative site can be forwarded by the subdivision officer and obligor Tahsildar and the Patwari subordinate to him under and only upon a direction from Deputy Commissioner to do so. Admittedly, no appeal was preferred against the said order dated 25th March 2014. A report is called for from the Assistant Settlement Officer present today to furnish as to whether alternative accommodation as provided or contemplated or proposed to the petitioner. The matter will appear in the list on 7th August 2024 for the year. No report has yet been filed.
Yes, madam. Where is the report?
August. In my report, it's stated.
Affidavit? Submitting report? Yes.
Subject line for the adventures for already in possession of the.
Who has prepared the civil? Who has prepared the civil? Against whom? Not against the writ petitioner. Not against the writ petitioner. Against whom? The civil suit against whom? Who has filed the civil suit against whom? The some others, because it is 1991, they held that they are in occupation, that the Tahsildar has given that alternative land. You are not challenged that. Subsequently order. This suit is filed by against whom it was filed?
Administration.
Administration. No, that court has passed an order for alternative. For the directed alternative. Yes, alternative. If it is not available, how you can say?
It just already filed as a suit, just pending. So where?
No, kindly come to the order passed by this court. Kindly come to the page 55. Page 55. 59, the cooperative portion. This order is to be read with order dated.
To demarcate the land.
Where is the order dated?
25th March, no.
22nd November 1991.
Just
Because they said authorities shall also see the other direction passed in this in the order date.
14, March 25, 2014.
Where is that? Where is the 25th March 2014?
in the report, plot would find at page 7. Page 7. In the report at page 7. Page 7.
Yes. Suppose for alternate, can you see?
Mandatory. Page 8.
Recording a name the petitioner as tenant in respect of the same within a period of 2 months from the date receipt of the communication from the sub-regional officer, provided the petitioner entitled to such recording allotment accordance with law. It is made clear that in the event the petitioner not entitled to such allotment, recording their names as tenant, record their funds shall pass a written order. But you have not denied that, and thereafter this court has further passed an order.
Past that is page 10, my report.
Page 10.
of my report. That's the recent order that I have passed.
Like we thought about set aside also. This order which we brought, they said it was set aside by this school again.
This is of 2014.
Yes, it was set aside again. That High Court order have not annexed lordship, but that has been set aside. Then again.
That's set aside. The concerned assistant commissioner settlement director to act in terms of the order dated 25th March within 5 weeks. Then you have passed this order. That is at page 30. 30. You have passed an order after due consideration of case hearing the discovery of the original allotted case file, physical possession certificate contained therein duly signed and taken over by the original authority of New Journal. I am of the opinion is not entitled to any. So what has happened to this order? Mr. Jaipal, order dated 2016, 30th March 2016. Have you challenged this order?
It was again challenged.
Yes, by which
That order have not annexed lordship this month.
by which writ petition?
Just one second.
Page 55.
Page 55.
With that petition.
Ah.
2017. That was challenged, page 30.
So, we have received the notice.
No, that what is the page 55? So, on is the 2016 writ petition. Page 55 of the writ petition. Page 55 of the writ petition, which against which order? अच्छा.
So against the application for
16 16 is what is happening. The 51 first solar that first solar that no order right.
Then you have to see what page 55 against which order?
What are the most record solar?
Then what has happened after 2017? 2016, then order was there. Thereafter, you issued the notice on 2017. What has happened thereafter?
Nothing has been.
Nothing.
We have received a notice that the private, when we went for eviction, then the private.
No, not 2000. Kindly come to page 60. Page 60. Notice. Page 60 of the writ petition.
Yes,
Good.
we wait for demarcation.
Then what has happened after that?
This private respondents that they have.
Where is the report?
They are, final, there is the final answer. And on the page 37 that we have received the notice.
It's 7.
And when we went for demarcation, we came to the results.
28th, you received the notice. Then you issued this notice on 30th August. Then what has happened after the 30th August?
We have issued, we have received on 31st. It may not see the same,
31st of August.
31st of August, we know that on 30th August, we have issued this notice, but on 31st, we have received this legal notice. So we couldn't proceed to the demarcation.
So you could have been informed, where is the order? Where is your order?
Lord, if they cannot evict them, alternative land, Tahsildar have suggested it. Justice Devashish Kar Gupta have clearly held mandatory order. You give an alternative, not there are several encroachment drives being raised. I can place those newspaper. Several lands were restored upon encroachers being removed. Lands are still available. I can identify them. They say that they don't have land. I can identify them. As a lawyer for the petition, I can identify. I will read the papers. Their own publication made by the Deputy Commissioner. That encroachers removed this much area of land has been restored to the government land within Fragrant Tahsil. And there are orders of High Court one after other. And they now, I understand, no, the person is sitting in my land. It's not possible.
But Mr. Jaipal, subsequent order July 2017 is otherwise.
Of Justice
Tandon order.
Yes, demarcations order. But no, this has to be read as a whole.
Once the order passed, subsequent, you have not challenged this, or you are not brought to the notice.
No, now they are saying that demarcation, they had been to demarcation, some other parties are there. You have to give the alternative. Because this order, no, kindly see the order passed in this case on 2nd August 2021. Shown it.
Yes.
They have to, because Tahsildar proposed, SDM processed, their own authority says alternative land is to be given. What else is required? In accordance with law, the file needs to be prepared. It has to be moved from one table, and after an approval being accorded by Lieutenant Governor, alternative site is to be given. Several cases are there of our High Court, Lord. The alternative site has been given.
This is not the report, madam. This is your fact. What about the petitioner's occupation and earlier orders? There might be a civil suit, but what about the present petition? This status of your Tahsildar has recommended, or SDO has recommended, court has passed an order. Then what has happened? You are not challenging that orders. What has happened then? Yes. They are approaching since beginning. They are approaching since beginning. Then you do one thing, Mr. Jacob. Whatever the orders
Dates.
compiled,
Yes.
come with the order,
Malad.
or you take instruction from the authority. In the meantime, fixing on Wednesday.
Malad.
Heard the Learned Counsel for the parties. This court find that several orders have been passed in several proceedings by this court. According, the petition is directed to file the compilation of the orders passed by this court from time to time. In the meantime, the government pleader is directed to take instruction from the authority in connection with authority in terms of the for compliance of the order passed by this court dated 2nd August.
Yes.
2nd August 2024. This is the matter on Wednesday dated 9th July 2020. Under the same. Yeah, hearing है ना? That's all. Anything?
No, the item number 10 and 11, I've already submitted the obligation before the registrar, right? I served the copy to the registrar.
You will reply.
Yes.
10 and 11?
I appeal for respondent in the.
Yes. Have you filed the affidavit? Record and order. Assistance Supreme 10 and 11. 10 and 11. Not counsel for the respondent. File affidavit. Respondent number 1, 2, and 4. 1, 2, and 4. 1, 2, and 4. File affidavit in opposition. After serving the copy to the learned counsel for the petitioner. Will counsel for the petitioner place for time to file reply. Let affidavit reply be filed by 10 days.
2 weeks.
By 2 weeks.
2 weeks.
Will the matter before the next available substitution. 10 in 11 same order. Huh? 10 in 11 same next substitution. Next.
This can be taken up, Lord. Very short issue in your service.
FMAT.
Lord, what has happened? Lord, I have a property at Lamba Line. Lord, the airport authority, invoking this airport authority Act 1994, passes an eviction order in respect of a landed property which is a government revenue land. It can't be done. It's not a public airport premises. I'll show that order. Page 44 is the impugned order.
44.
44. And the Lord would see page 45, the
I was directed to file affidavit and filed it and serving a copy.
I will not use reply, Lord. There is no negative. I will. Finally come to page 45, my Lord.
You are Amarjit Singh.
Amarjit Singh.
Amit Singh.
Amit Singh, son of Amit Singh, son of Amar Singh. Page 45 may kindly be seen, my Lord. The airport authority claims survey number 66 to be their own land. So this eviction order has been passed under the Airport Authorities Act in 1990.
Yes.
So, Lordship, if it's a revenue land, the airport authority have no business. I'll show that document. Page 37 of the writ petition. And now kindly comes to page 39. 36, the records entry starts, page 39.
So what order they have passed?
Eviction, evicting me from the survey number 66 because I'm in my property, I'm having some excess land. It's a government revenue land.
131, considering the another survey number 766.
66. I'll show the record entry. Which I have obtained on 3rd of January 2021. Kindly see page 39. 39. Not would see this 4th serial. Government Revenue Department.
39.
Government Revenue Department, survey number 66 at the top, Lamba Line, same will. It's not, it's a government, if it's a government revenue land, then under regulation 202, order needs to be passed. I have a right to challenge the order in a civil suit. They have curtailed my right, Lordship. I'll show the Airport Authority Act also, Lordship, because they have invoked this provision.
What is their defense?
They say it's a.
You are right.
Well, kindly see the definition. I'll just show the airport premises. Definition of airport premises.
Airport Authority Act. Airport Authority Act. You have a copy, man?
I don't have it.
No, I can give.
Extra copy?
No. So this is something like it's akin to public premises act. If it's a public premises, PP Act would come. If it's a revenue land, then LR. Not kindly see
Section?
28D. And one would see airport premises has been used and that has been defined under the definition clause. What would be an airport premises?
Yes. Airport premises have been defined.
Yes, my lord.
Section? Yes, next.
So my first and foremost point is, my lord, this order cannot be sustained in the eye of law because the airport authority have no business. If at all I am to be evicted, it has to be in terms of regulation 1966. That's the first point. Secondly, I'll show you. Sponsor.
Yes, next.
Secondly, my lord, in the impugned order, my lord would see certain adverse reports were relied to come to a finding as against my client. And my lords, there cannot be any debate on the point that if adverse material is collected against me, opportunity has to be given during the hearing.
Yeah.
Normally, what authorities did here, my lords, in the impugned order, they will reflect. That's not the principle of natural justice. In course of hearing, if they call for certain reports, they have to give me, I have the right to deal with it. Then a decision has to be taken on the point which I have raised. This has not been done.
Which report you are referring?
Just 1 second, I'll just.
Document annexed thereto, including the revenue authorities letters to the airport authorities and the demarcation report. Together with the map included.
Just 1 second. My lord. Some survey reports were relied, my lord.
Yes, page 46.
Yes, my lord.
Findings.
Yes.
Last 5 lines.
Yes, my lord.
So your contention is that this has been not given to you.
Yes, my lord.
Applicant documents annexed here, including the revenue authorities addressed to the airport authority, demarcation report.
Nothing has been, nothing. I have taken this point.
And the state appeal.
Yes, ma'am.
Number 1 of the Then
mainly on these 2 points.
Yes.
I have challenged the order impugned.
Okay.
My lord, they have filed their opposition. Lord, kindly see at page 36. Page 36. The Tahsildar gives this letter on 7 January 2025.
Yes.
Particularly when few other writ petitions by the same parties which are fixed were pending. Well, kindly see. This is with reference to the letter dated 17/12/2024 on the subject cited above. In this regard, it was to inform that upon verification of available record, it has been found that land bearing survey number 66, 67 and 68/2 area so much is currently recorded in favor of Government Revenue Department. It rather strengthened my case. In the last paragraph it says, however, it is pertinent to mention here that the said land was acquired for the extension of aerodrome by RC number so and so 1965. Fact remains, Lordship, it's a revenue land. If they want to throw me, then the Tahsildar can do it. Airport authority cannot do it, Lord. This one. Secondly, but I have my own property. I'll show my records. Now they want to throw me from my property, which is at page 22, in the name of Amar Singh. He's no more. He's died.
22 in the
Writ petition. 22.
Yes. 61/8.
Yes, my lord. These are my properties which is contiguous to survey number 66. And my lord knows in terms of page 25, I have a right to get the excess land regularized if it's a government revenue land. Page 25, the scheme. I have a right. The authority may regularize, may not regularize, but I have a right today. This has been curtailed. I have filed the documents to show how I am related with my father, Amar Singh, local certificates. Now, kindly see page 30. Again, page 30, a notice was issued by the Tahsildar because that prompted my client to file an independent writ petition, which is pending. With reference to application number so-and-so, this and so-and-so, situated number and belongs to Airport Authority of India. It says that it belongs to Airport Authority of India. Where are those documents, my lord? Then this proceeding was challenged by my client in an independent writ petitions which are pending today before my lord's list. Then my lord 33 was prepared. 33 was prepared, showing that my predecessor Amar Singh was having an area of 131 square meter in his possession along with his recorded land.
33. What is the survey report?
Its report, not which is serial number 1.
Under physical.
Physical Amar Singh. And Malad kindly turns to page 34 then. Then I raised my objection at page 35, my lord. So these are the material upon which I place reliance, my lord. And I say, my lordship, because the land being a revenue and as of now, if it has been acquired, my lord, the records would indicate that. Simply Sitter Tahsildar giving a letter that to during 2025 will not make this land to be a public airport premises. It can't be. Because the Tahsildar acknowledged my case. It says that it's a government revenue land. At best, it could have been done. But what lordship under the PP Act is being done? If a person is found occupying a government land, the government makes a request to the estate officer. Estate officer passes an order.
Correct.
The same way, they could have approached the Tahsildar under 20. Tahsildar could have adjudged because it's a government revenue land. Because my land is affected, lordship, and the contiguous plot holder. Under the garb of eviction order, they would throw me from my land as well as excess land. They will remove. The airport authority has no jurisdiction to pass an order. That's the first point.
There are 2 points raised by my little brother. The first thing is I am not the recorded owner. It is no doubt it is reflecting as a government revenue land, but however, we have apprised the revenue authority stating that look, my land has been reflected in your record in such a, because when the computerized upgradation was done, so it was not reflected. So application was made by the airport authority, and I've been told by the airport authority that within 10 days they are going to change the name from revenue department to the airport authority. First thing. Second thing, from my little brother stated that no opportunity was given to them fully and no copy was supplied to the other side. However, from the judgment, it reflects from the second paragraph, the respondents were given an opportunity to present their case during the hearing held on so and so. The respondents were physically present and demarcation report prepared by revenue department was provided to them.
Where from which page you are reading?
Page 12 of my affidavit in office.
Page 12.
That is the impugned order which has been challenged by the other side.
Okay.
Paragraph 2.
Respondent were given an opportunity to present their case during the hearing. The respondent were physically present and demarcation report prepared by the revenue department is provided to them. However, a short time to file return reply in respect of survey provided given time to submit reply by 15 January. Notice of final hearing was also submitted. Yes.
This it is very much clear that they were given ample opportunity by providing with the demarcation report. Had it been a revenue land, why the revenue will conduct a demarcation? They will say, no, we cannot do it because it belongs to us. Because they are aware from their old records that it belongs to airport authority. That is why a detailed demarcation was conducted and the report was prepared. And to give them the fullest opportunity, copy was supplied to them so that they can file their respective objections. So when it is categorically submitted in the demarcation report that the land which is under the occupation of the appellant belongs to Airport Authority of India, the airport estate officer has exercised his power and he has passed the eviction order, rightly done, because he has been empowered under Airport Authorities Act. Similar situation arose, Your Lordship, on the earlier occasion. The state appeal was filed by one Mr. Muhammad Ibrahim. That copy I have enclosed in my affidavit in opposition. Where the question arose that since the land belongs to Airport Authority of India, therefore the estate officer of Revenue Department ceased to have any jurisdiction. That order is, Your Lordship will find it page 70 of our Honorable District Judge. The state appeal number 1 of 2020. So I will not be reading the entire question, but the operating portion. Always, page 32 RP. Both parties have submitted that this proceeding should be dismissed as because the estate officer ADM passed the order without having jurisdiction, and the estate officer appointed by Airport Authority of India will have jurisdiction to entertain the case. If that be so, then the appeal should be allowed as prayer of both parties on the point of jurisdiction of estate officer, and the judgment cited by the side of appellant reported in such and such will have no effect in this case, as because it is a plea from the side of appellant itself that the appeal should be allowed, as the order passed by estate officer at ADM is in its nullity. Because State Ibrahim was also found to be in possession of the land, which is the Lordship will find from the very demarcation reserve. This Muhammad Nazim Khan happens to be one of the petitioner. So they all were found to be in possession of the same airport authority's land. So that is why this order was passed, because earlier another estate officer has taken the plea, then we apprised the court that
Revenue authorities are the party here? No.
No, sir, not because the eviction order has been passed by the eviction officer.
But not the problem with regard to you raise the point with regard to the property.
I will
You-
then make them. I'll
You
make them.
make the problem
Well-
and then let the file the report with
My lord.
regard to this.
My lord,
yes, that is the.
My lord.
Let me back down.
my lord,
Let me
my lord.
The dispute in the present writ application with regard to the land bearing survey number and land measuring an area of 131 square meter. Measuring an area of 131 square meter. क्या बोला? 131 in survey number 66 situated at Lamba Line village under Kolkata South. The airport authority claims that the land belongs to the airport authority, but the writ petitioner has illegally occupied the
One indulgent, it's a affirmative.
appellant.
The other case he has included
The appellant is in illegal occupation on the said premises, and accordingly, the airport authority has who has passed the order?
Eviction officer.
The eviction officer of the airport authority has passed the eviction order dated
dated
2012-2020, I just
dated
3rd of March 2025.
3rd of March 2020.
3rd March 2025. As per the order passed by the, as per the judgment passed by the state officer, eviction officer of the airport authority, he has relied upon the demarcation report of the revenue authority. The petitioner has disclosed the website copy of the land record of survey number 66, wherein it reveals that the land bearing survey number 66 of Lamba Line village is recorded as government revenue. The contention of the petitioner is that if the land belongs to the government and recorded as government revenue land, thus the airport authority has no authority to pass an order of eviction. Full stop. Considering the submission made by the counsel for the party, this court find that the revenue authority is the necessary party to decide the present appeal. Accordingly, the petition is directed to add the deputy commissioner,
Tahsildar would be.
the deputy commissioner as well as Tahsildar Purbe Tahsil, deputy commissioner Southern district Vijayapuram, as well as Tahsildar Purbe Tahsil Sivapuram, I guess Vijayapuram, Sri Vijayapuram be added as respondent number
2 and 3.
2 and 3 in course of the day,
Post lordship's effection I can.
by Tuesday, and to serve the copy of, serve the notice upon the deputy commissioner as well as the Tehsil appointment Tehsil within a week thereafter. List the matter, full list of, on receipt of the notice, the deputy commissioner as well as the Tehsildar are directed to file their report with regard to the status of the land bearing survey number 66 situated at Lambaland village under Vijayapuram Tehsil within a period of a week thereafter. List the matter before the appropriate.
There is an interim order passed.
It is going to
Yes.
expire today.
No, it was passed when the first date was moved. By justice, there's an interim order.
The order was served on 9th of April 2025.
It's for until further order.
Yes.
Until
Further
further
order.
order.
Fine. Until.
ये हमारा अरे और क्या खाना खाने देगा कि
Today, bro, after lunch.
not today.
Go.
No. Come on Monday. Yes, Mr. Chakur.
Monday having some difficulty, but
No,
we make a request.
no.
Just wait.
Let's-